All right, let's get into it. Today, we are diving deep into one of the biggest, most high-stakes corporate throwdowns of our time, Apple versus Samsung. And this was so much more than just a fight between two tech giants. Nope, this was a battle that forced everyone to ask some huge questions about what innovation really is, what good design is worth, and where we draw the line with competition. So where do we even begin with a story this big? Well, we have to start with this number, a number that just absolutely rocked the world. We're talking over $1 billion. I mean, that's the kind of figure that turns a tech squabble into a massive global headline. And it made everybody, and I mean everybody, ask the same thing. Yeah, how? How did a fight over something as simple sounding as rounded corners blow up into one of the biggest corporate payouts in history? That's really the core question we're tackling here. And trust me, the answer isn't just about phones. It's a story that completely changed the game for tech, for intellectual property, heck, for patent law itself. So to really get our heads around that billion-dollar number, we've got to hit rewind. We have to go all the way back to the beginning. And this whole saga, it doesn't start in a stuffy courtroom. It starts with a product. A single product that landed like a meteor and just changed everything. Okay, so you've got the iPhone in 2007, changing the world, then the App Store in '08, building this whole new universe around it. But then, in 2010, the plot thickens. Samsung, who was actually a huge parts supplier for Apple, drops the Galaxy S. And when Apple looked at it, they didn't just see a competitor. They saw a copy, a blatant one, in their eyes. So by 2011, boom, they filed the lawsuit. They were framing this as an epic battle to protect their revolutionary idea. And Apple did not come to play. Their legal team, a real powerhouse firm, went straight for the jugular. Their argument was brilliantly simple, but incredibly powerful. They said, look, it wasn't just a feature. The entire phone was the thing they copied. And because of that, we want all the profits from that entire phone. They were basically painting a picture that Samsung's meteoric rise was built on the back of Apple's blood, sweat, and tears. So yeah, the battle lines were drawn. The stage was set for this absolute clash of the titans. The whole thing landed in Judge Lucy H. Koh's courtroom. And for the next few weeks, forget reality TV, this trial was the show everyone in the tech world was glued to. Okay, so let's get into the nitty-gritty of the legal fight. It all came down to two different kinds of patents. You've got your utility patents. That's all about how something works, the guts, the function. And then you have design patents, which is purely about how something looks, the cool ornamental design. Apple sued over both, which brings us to the key question. Was this a fight over how the phones worked or how they looked? Right away, the courtroom turned into this battle of the brains, a real theater of experts. Apple paraded out their witnesses armed with all this complex survey data. They were trying to prove that, yes, people were genuinely confused and that they'd totally pay extra for Apple's special features. But then Samsung's lawyers got their turn, and they just tore into those experts, questioning every little detail of their methods, basically saying, hey, this isn't how real people shop for a phone. So you can imagine what the jury was dealing with, right? They were getting two totally opposite stories. On one hand, you had Apple's designers on the stand talking emotionally about the blood, sweat, and tears, the pains and expenses that went into creating the iPhone's iconic feel. But then Samsung's side would come up and say, whoa, hold on, we were just competing. These design ideas are becoming standard in the industry. They're just functional. And then, the moment of truth, the verdict. The jury went out, and after just 3 days, which is lightning fast for a case this complicated, they came back. And it was a knockout, a complete sweeping victory for Apple. The jury said Samsung had willfully infringed, and they handed down that jaw-dropping number, $1.049 billion. Now, you'd think a billion-dollar check would be the end of it, right? Case closed, but no way. This fight was never just about the money. It was about setting a precedent. And this thing was about to go to the next level, all the way to the Supreme Court. So now we're at the Supreme Court. The whole game changes here. The conversation wasn't about if Samsung copied Apple anymore. It became about a much, much bigger, more fundamental question. How do you put a price tag on a design? And it all came down to this kind of obscure legal term, the article of manufacture. Sounds boring, I know, but stick with me, because this was the billion-dollar phrase. See, the law says if you copy a design, you have to fork over your total profits from that article of manufacture. The huge question was, what is the article here? Is it the entire phone you buy in the box? Or is it just the specific little part, like the shiny bezel that has the copied design? Standing before the highest court in the land, Samsung's lawyers basically said, this is crazy. They argued that it's completely absurd to make us pay out all the profits from a super complex smartphone, a device with thousands of patented parts inside, just because we allegedly copied a few cosmetic things on the outside. And you know what? One of the justices totally got it. Justice Stephen Breyer came up with this killer analogy that just cut right through all the legal jargon. He said, think about a Rolls-Royce. If someone copies just that little silver lady ornament on the hood, should they really have to pay out all the profit from the entire car? And just like that, boom, everyone understood what was at stake. So that was the showdown right there. You had Apple sticking to their guns, saying, hey, you sell the whole phone to the customer, so we get the profits from the whole phone. And then you had Samsung arguing for a more, let's say, reasonable approach. The damages should match the crime, tied to the value of the part we copied, not the whole thing. And believe me, every company that makes anything with more than one part was watching to see how the court would rule on this. So in the end, the Supreme Court's big decision didn't really crown a winner in the Apple versus Samsung war. But what it did do was tear up the old rulebook. It completely changed the rules of engagement for every design patent fight that would come after. And here's the kicker. It was unanimous. All the justices agreed. They sided with Samsung's argument, ruling that yes, damages can be based on just one component, not necessarily the whole product. This was a huge, landmark decision that completely reset the financial stakes for this kind of lawsuit. The case got kicked back down to the lower courts to figure out the new number, and after a few more years of legal bickering, the two giants finally just settled the whole thing in 2018. So think about that. This whole epic war started with a pretty simple claim. Hey, you copied my phone. And it ended up setting this incredibly complex and powerful new precedent for the whole tech world. It basically said two things at once. One, yes, design is super valuable and protected. But two, there's a limit to what that design is worth when you're talking about a product as complex as a smartphone. And that really leaves us with this huge, lingering question, one that courts and companies are still wrestling with. Where do you find the right balance? I mean, how do you protect the real innovators, the people who come up with something new, without letting those patents become a club to just beat down your competition? This case didn't solve that puzzle, but it sure did force everyone to start talking about it. Thanks so much for diving into this with me. And just a reminder, this is for entertainment and educational purposes only. This is not legal advice.